Gavin Newsom versus Donald Trump comes back down inside the 9th Circuit Court of Appeal in San Francisco. I want to do a follow-up. The ruling comes down today, technically late last night. So let's break it down, give an update. I went down to the court hearing on the original hearing when this was heard on a TRO. So what happened first is that Newsom sued the president for declaratory and injunctive relief, asking the court to get him to stop using the National Guard here in California. He then got a TRO issued by Judge Breyer there in San Francisco, and I went to that, granting relief to the governor, saying the governor saying the president's not allowed to use the National Guard in California in this situation. He then went ahead and appealed it. The president immediately appealed it, and a stay was granted. Then after the stay was granted, they had a hearing on the stay, and I went to that as well in the 9th Circuit. That was on Tuesday. And now the briefing came out, and the stay was officially granted. Now, what's interesting is he's got 3 judges there on the 9th Circuit Court, two of which were appointed by Trump, one of which was appointed by Biden. All of them ruled in favor of the stay being put into place. And it was it came down to this issue under 12406. It's a Title 10, 12406 political question doctrine. Ultimately, did the president have authority to invoke the National Guard? And if he did he meet those elements? So the first thing they decided was judiciability. Like, did they have jurisdiction to rule on it? Well, they said they definitely did have jurisdiction to rule on it. And that was because it was limited, though. They said the courts can review 12406 actions to ensure statutory compliance, reinforcing judicial oversight. So just like limited capacity, they decided they can review on this. It's not separation of powers. That's their own decision. It's a legislative statute. So the review, though, is extremely limited, super small. Basically just like only on review what the president did and whether or not an emergency decision was egregious or like a total abuse of discretion. Apparently they can review that. That's what they said. Now, president's authority under 1203 was, inability to execute the laws. So they found that he was unable to execute the laws because there was an invasion or massive riot going on and a rebellion happening. And they looked at the declarations and the facts. I mean, I think they said that Molotov cocktails were going off, protesters were attacking federal agents, the properties were massively damaged, even the federal courthouse was even damaged, and officers were even injured. So it seemed like an invasion. They were not able to, they met all those elements. Basically, the next one was the procedural requirements for 4206 and the orders issued through the governor. This was interesting because the governor's saying, well, you didn't issue it through me, but there's a statute in California, which is the military statute. I thought it was kind of interesting, kind of a nerdy thing on like a legal issue, but it's like they have this military statute. It says, it's under California law, Military and Veterans Code 160 and 163, which authorizes the adjutant general. He's authorized to issue orders in the governor's name. So the guy in charge of the National Guard in California is the adjutant general. He's authorized to issue orders through the governor, in the governor's name. And that's right out of the military code in California, 160 and 163. The court found that's exactly what happened, is that Donald Trump issued the order through the adjutant general in the governor's name. That's following California law to a T. Yeah, there's a 10th Amendment argument about California brought forward saying that, ultra-virus, which I don't even know what that means, ultra-virus claim, I don't even know what that is. I'm not going to look into it. But a 10th Amendment claim hinges on a statutory violation. And so it's not a constitutional issue here. It's a statutory violation issue. So 10th Amendment claim does not apply. Just reinforces the militia when statutory is authorized and limiting state sovereignty challenges. So it's, they completely overruled the 10th Amendment backup argument by the governor. Now, the other one says the stay is going to remain in force. because of the irreparable harm to the plaintiff and injury is not relevant. He said that the plaintiff, in this case, the governor, was saying that they're being injured because they have potentially not able to fight forest fires and potentially not able to have another potential threat that hasn't happened yet. And the court found those are all speculative, way speculative. None of them are real, have happened yet. We don't know. So they completely overruled all that. And then the public interest saying protecting federal agents and property of federal property outweighs speculative potential threats that California had. So the stay was granted, and then the defendants, also the defendants, President Trump, likely to succeed in the case. What's also interesting is that Judge Breyer up in San Francisco, he had his order to show cause hearing today. So he's still going forward. He's having his order to show cause, and he'll probably still keep ruling in favor of the governor on the order to show cause and why the preliminary injunction shouldn't issue. The preliminary injunction is like the final injunction at the court level, district court level, that's supposed to rule on it. Now, this crazy 80-something-year-old judge just completely doesn't care. I don't think he'll probably still rule. They had a hearing today. I didn't see the ruling. They had a transcript. Everybody ordered transcripts. I don't know what's going to happen. But I would imagine he'll probably rule again for the governor, even though his boss, the 3 circuit panel in the 9th Circuit, 3 judges, all just overruled him. I would think he would care about what they had to say, but I don't think he will. So we'll see. That's a little update. 9th Circuit throws the hammer down on the state of California, the Gavin Newsom versus Trump claim. None of the issues about like state sovereignty really applied. That was like the 10th Amendment stuff. So those issues are moot. I thought it was rather interesting about the state sovereignty thing because it'd be a fascinating discussion. Are the states sovereign? But none of that ever came up. The court's not going to go there right now. It was pure statutory. So more to come. Just wanted to do a short update on that. If I find something else interesting, I'll report on it. But otherwise, this matter's consider it closed at this point. I don't think Judge Breyer might do something else crazy. If he does, I'll report back. But if not, we'll close this out. Gavin Newsom fails versus Trump. More to come. Bitcoin stuff for sure. Big week coming up next week. I am going to do Tree Chat next week. And also a couple other shows I've got. I'll have to check my schedule, but it's going to be good. Hit the ones. Be sure to subscribe. Tomorrow I'm in Sacramento. I've got the A's and the Cleveland Guardians. They changed their name. So going to that for Dad's Day, late Dad. I wasn't able to see Dad for his Father's Day last weekend. So doing that in Sacramento tomorrow at the game, and it should be really fun. Right there. Great seats, man. I was able to get amazing seats right there. So Sacramento A's. Boom. Can't wait. And then looking forward to it. Hit the ones. All right. Subscribe, comment. I'll see you at the top.